Hello, welcome to our webinar today. And my name is Fan Yang. I'm a partner from Stephenson Harwood. And tonight we have the pleasure of having Mr. Huang Guoyong, Director of International Cooperation and Development Department, Free Trade Zone Arbitration Department of Shenzhen Court of International Arbitration, to deliver the opening shortly. And towards the end of tonight's webinar, we will have Jane South, Managing Director of CEDR, to deliver the closing remarks. We are going to follow the program that you have all received, and as you have all have the detailed introduction, detailed profiles of all the speakers, we will try to be brief on the introduction part. And without further ado, please join me and welcome our first speaker of tonight, Mr. Huang Guoyong, to give the opening speech. Thank you. Mr. Huang, over to you.
Thank you, Dr. Yang. Distinguished guests, ladies and gentlemen, good morning, good afternoon, and good evening. On the behalf of Shenzhen Court of International Arbitration, SCIA, I would like to take the privilege as a co-organizer of today's webinar to welcome all of you to join us online, despite the places and differences of the time. I would also like to extend our sincere thanks to our cooperation partner, IDRA, CEDR, Stephenson Harwood, International Energy Charter, ICSID and UNCITRAL, for their contributions to the webinar. Special thanks go to Dr. Yang Fan for her dedication to put all these wonderful programs together. Today's webinar will focus on ADR for investor-state disputes, especially on mediation of investor-state disputes. We are honored to bring together an array of distinguished speakers based in mainland China, Hong Kong, and other parts of the world with unique experience and insights in both commercial and legal sectors, and from both institutional and practitioner perspectives. In the context of the Belt and Road Initiative and Guangdong, Hong Kong, Macau, Greater Bay Area, we believe that Chinese economy will get more and more involved in the global economic cooperation, and we are stepping into a new phase of development. In terms of investment, China has become one of the top capital importer and exporter in the world. This explains why the application of investment arbitration and mediation has become a very hot topic among the law societies and business societies in China. And ADR for investor-state disputes bears great importance. Investor-state dispute settlement is a relatively new mechanism. As a best-known institution devoted to international investment dispute settlements, ICSID itself is only about 55 years old and have only had investor-state jurisprudence for roughly 29 years. We are delighted to tell that in order to adapt to the market demand, the SCIA, as the first arbitration institution established in Greater Bay Area, took the lead in China, introducing investment arbitration in 2016. SCIA updated its arbitration rules, becoming the first arbitration institution in Chinese mainland that makes clear its rules to accept investment arbitration cases and administer such cases under the UNCITRAL arbitration rules. In 2018, the SCIA entered into cooperation agreement with ICSID at Washington, D.C., according to which both sides will promote ADR jointly and provide each other with hearing facilities and relatively services. Last year, the SCIA became the exclusive national organizer to annually run the China National Round for the FDI moot, one of the most prestigious moot court competitions worldwide, aiming at helping future practitioners gain practical understandings of investor-state dispute settlements. I have to say that the audience are very lucky today, as we will have 6 speakers with rich experience in the field of investment dispute settlements to share with us the best practices on effective use of ADR processes in management and resolutions of China-related investor-state dispute. I believe that each and every one of you will have a very pleasant and fruitful time with us today. Thank you, Dr. Yang Fan.
Thank you, Mr. Huang, for your very delightful welcoming and opening remarks. And thank you also for your expectations. And so now we're going to move on to our first speaker of tonight, Mr. Alejandro Caballo Leda. And Alejandro is the General Counsel and Head of the Conflict Resolution Center in International Energy Charter. And his topic tonight is the prevention and management of investment disputes, the model instrument. Alejandro, over to you. Okay.
Thanks. So, welcome to everyone. Good evening again. Good morning. Good afternoon. My topic will address both prevention and management of investment disputes, and will focus on a particular model instrument, which I will explain is some sort of a guidelines that member states can use in order to implement their own internal framework. Now, sorry for that technical lapses. So basically, economic activities are usually quite regulated, result in quite a frequent interaction between not just the foreign investor and a ministry or an agency, but several agencies, several ministries, several entities from the government. And it's not so infrequent that in many cases, some of those government entities, agencies, are not completely familiar or very well aware of all the international and contractual obligations, even sometimes unilateral promises or commitments that the government have made with the foreign investor. And they may have been undertaken at different levels. They may have been at the customs office, they have been at the particular ministry or agency, and not everybody is aware of those potential obligations. And therefore, it's not so infrequent to find out that inadvertently, without a real intention, there is a violation of those commitments. But this is not only in relation to the governments. This also happens with companies. Sometimes we have big companies with many subsidiaries, and they are not all the time very well aware of all the commitments and obligations enter into different countries where they have the foreign investment. Therefore, it's quite important to have a quick and coordinated reaction in order to try to diffuse as soon as possible any potential problems, grievances, misunderstandings at the very early stages before they really convert or escalate into a really important dispute. For that, what you need, we need really the framework. We need to have an internal framework, both for the companies and for the governments, to know what to do and when to react in case there are problems. But not only having an internal framework. Having a framework is not enough if you don't raise awareness and capacity building. So it's very important to have the framework and to make sure that those who are interacting either with the foreign investors or with the government officials in relation to a contract or a foreign investment, they are familiar with that internal framework. Now, in 2018, based on several consultations, the Initiative Secretariat, in cooperation and discussions with several international organizations and government officials, and after some events for discussion in Europe, Asia, America, and Africa, developed what I mentioned before, a model instrument. It's some sort of a guide, a model, similar to UNCITRAL models for arbitration, and that could help or could guide governments, providing different options to consider implementing their own internal framework. In addition to that, it's very important to mention that that particular model instrument also addresses the concern of how to make sure that mediation and early assessment will be really considered and given the real importance they have. This model instrument is to be considered by the governments, and they can implement, taking into account their own specific particular needs. We currently, Secretariat, provide assistance and capacity building for some governments. We have some European and some African countries who are interested, and we provide some information, and we made some assessment of their actual situation and provide some assistance in potential developing such instrument according to the needs and realities. In addition to that, the Secretariat also have a conflict resolution center where we provide good offices and mediation in support of investment disputes. Now, the important thing here I want to mention is that this model instrument was initially developed to make sure that governments can have a basic internal framework on how to deal with those disputes, how they can coordinate, how can react in time, how they can also take into account in the early assessment the possibility of investment mediation or negotiation. But this is not just for governments. This is a particular model that can also be used for companies. And it's very important because if we're trying to make sure that investment disputes are solved in an amicable way, then you not only need the governments, but you also need the companies to be involved and to be able to engage in that discussion. What are the main characteristics, the principal tools you can find in that model instrument? Well, we can divide into groups, some for prevention mechanisms and some for managing already potential conflicts or disputes. In regards to the prevention, the first thing is to have an organized, centralized, and consistent database. So one of the important things is for the company or for the government to have a clear understanding which are the problems that were in the past, how those problems were addressed, what kind of tools or actions really work, or if those who didn't work, why didn't work. Then you can learn from the past and your previous experience. Another important thing is to have stakeholder mapping. You need to understand as a company, as a government, who you will be interacting with. If you're a company, who are different agencies, ministries, entities, maybe also the local community that will interact and will have an impact in your investment. The same from the government side. To have a consistent, uniform dispute resolution clauses. If you apply always similar type of dispute resolution, you know how to react and when to react at which point in time. Also to have a clear early analysis of potential policy changes that affect investment. Similar as companies do usually to have an early analysis of potential problems with the contracts, you also need to, or it's very useful to have an early analysis of what will happen if there are policy changes in that particular country, how those will apply and affect to the particular foreign investment. This will allow you, in particular, if you have a mechanism already set up, to react quite early and to follow particular steps. And then the person in the company or this officer, apart from the government, will be able to react quite quickly because they will know when to, how to, and to whom they will have to report in a timely manner. But always having into account that not all cases are the same. So some flexibility is sometimes needed. You cannot simply just follow the rules. You cannot just simply follow a hard book. Now, that was for prevention. That will help you when you have simply disputes or even before the disputes you enter into a country. Now, what happens when the conflict is already on the table, when the dispute already escalated? Then you really need to make sure, and it's really important for governments to have a clear internal coordination and to identify the person, department, unit, who is going to be in charge, who needs to be notified, who is going to take care or control of the negotiation, mediation, arbitration, who has the authority or who has the access to the person with authority. And this is not only important for governments, again, it's important for companies. If you really want to have a quick reaction and you really need to go to invest mediation, you need to consider who will be the person who will sit down there and negotiate with the government in case needed. Also, it's very important to have an early and independent assessment of the dispute. So frequently, the government receives the dispute and the only reaction is just to prepare for arbitration. Sometimes the company is the same. They have a dispute, they prepare for the arbitration. Now, the important thing is to really assess, evaluate for this particular dispute, mediation is possible, will be something feasible. It could be interesting to divide the dispute and some of it try to negotiate. So to have a clear assessment of what can work better in this situation, even taking into account the previous database of previous cases, what happened in the past in similar situations. When you have that database and this internal coordination, and more in this era, it's important to have, of course, your security measures to avoid leakage of information exchange, etc. And also to consider how all this, if you go mediation, negotiation, how this is going to be financed. This is not so simple for governments because they may have some internal rules for going arbitration or to go to international tribunals, but they don't always have a clear financial mechanism to get what they need to go for mediation. And finally, and also very important, is how to deal, how to address with the public, political, and media interests, and how to deal it within the framework of that particular government, that they may have particular transparency obligations. It's not just, for example, arbitration in a commercial dispute, where the parties may decide not to publish anything of what's going on, but here the government may be forced to publish the final outcome or the mere existence of negotiations in relation to solving a potential investment dispute. So how to deal with that in advance, how to be ready for when the time comes, and to identify a particular spokesperson that can come with a particular strategic communication plan. This is something that we have been developing with several countries, and we are also trying to discuss with companies how this can also be relevant also for them. Thank you very much. Fan, back to you.
Thank you so much, Alexandro. And I should also just quickly mention that for all the participants, please feel free to, write down any questions, use the chat function or the Q&A function on the screen, that you can ask questions anytime. And we will come back to you, Alexandro, at the Q&A session when we discuss this module instrument further. But perhaps at this point, I would just say that the creation of this responsible body, which is in the center of this model instrument, seems to me is a wonderful creation, especially this, inter-institutional level of collaboration commission, and we would like to hear more from you, perhaps at the Q&A, how it actually works, or not necessarily, depends on the domestic regime, the obstacles and the challenges and opportunities ahead. And we are now going to move on to our next speaker. Our next speaker is Ms. Frauke Nischke. And Ms. Frauke is the team leader, legal counsel of ICSID, International Center for Settlement of Investment Disputes. And her topic for tonight is the developments in ISDS and the ICSID mediation rules. And Frauke, over to you. Thank you.
Thank you, Fan. I'm delighted to be on this panel. We have such a wealth of information of investor-state dispute settlement, especially in mediation. And thank you, Fan, and your team to organize all of that. Okay, then we move to the next slide. So let's start out. When we talk about the proposed mediation rules from ICSID, who is ICSID? And we already got such a nice introduction earlier today. So it is true that we are the only multilateral institution that's dedicated to resolving investment disputes, meaning disputes between states and foreign investors. We've been created in 1966 and we're part of the World Bank Group. Really, the overall idea and mandate of ICSID is to assist in the resolution of disputes to facilitate economic development. Next slide, please. If we look at mediation as a resolution, the original convention in 1966 already included conciliation as a dispute mechanism, and Fan had asked me to speak to that, which I will do in a couple of slides further down. But if we look at mediation as a form as facilitated negotiations, how did that come on the international terrain? And here we mention the development in treaties that include specific mentioning of mediation for the settlement of investment disputes. Of course, the 2016 Guide on Investment Mediation, adopted and developed by Alejandro, and the Energy Charter Conference adopted that in 2016, and about 1/3 of ICSID's member states are part of the conference. And Judith will tell us more about the development and the multilateral work, and then the entry into force of the Singapore Convention, which is also intended to not exclude at the minimum investment disputes. And Alejandro already gave us an overview of the model instruments on investment dispute management, which has found quite a lot of uptake, and we discussed this in the context with our World Bank colleagues of economic development, and we'll get back to that in a couple of minutes as well. Next slide, please. When we look at the empirical data on settlement and resolution, if we look at the arbitration proceedings at ICSID, there's a constant number that is always over 30%, sometimes closer to 40% of arbitrations that end without a ruling of the tribunal, where the parties decide to discontinue or settle the arbitration, which is another indication that there is room for negotiated settlements with a facilitation of a mediator. Next slide, please. So why the ICSID mediation rules? I gave it away a little already. We wanted to provide states and investors with a neutral and trusted forum to engage in these facilitated negotiations. That is feedback that we received, that states wanted to really make use of mediation, but what they thought would be helpful is to do that in a neutral forum on the international level. Then offer the disputing parties a really broad access to investment facilities. I'll speak to that on the next slide about the difference to established jurisdictional requirement under the convention and the additional facility, which are the other sets of ICSID rules that we are known for, and the mediation is very different. Obviously, mediation as a process is flexible and party-driven. Time and cost effective mediations in the investment arena are said to take between 3 and 9 months, so much shorter than the arbitration route. And of course, we wanted to integrate the ICSID mediation rules into the framework of the Singapore Convention. Next slide, please. So what's the nature of ICSID mediation? It's entirely voluntary. As mediation in the commercial context, either party may unilaterally withdraw at any time. So we call this ongoing consent. This is different from the arbitration and conciliation mechanism offered under the convention or the additional facility. So you have the consent early on to enter and to stay in the process. And differences to conciliation. I put a couple of examples on the slide. The wide accessibility that we will speak to on the next slide. The conciliation mechanism envisions a 3-member commission that is much like an arbitral tribunal, appointed 1 member by each party, disputing party, and the presiding conciliator by party agreement. Whereas under the mediation rules, we have 1 or 2 co-mediators, both or the single one appointed by party agreement. The default in conciliation is a 3-member commission. The default, if the parties cannot agree whether it should be 1 or 2, is also 1 mediator. There's no jurisdictional determination by the mediator, and there's no preliminary or jurisdictional objections that you can file in conciliation that's not available under the mediation. Next slide, please. So I talked a bit about the scope and how it is different to the conciliation. And what we have in Mediation Rule 2 is to authorize the ICSID Secretariat to administer any mediation that relates to an investment, involves a state or a regional economic integration organization, and which the parties consent in writing to submit to ICSID. So you see here the written consent as the cornerstone. You need a state or an REIO as a party, and a mediation that relates to an investment. So you do not have here the limitations that you have in the convention, where you need 2 contracting states or the additional facility where you need at least one contracting state nexus. Here, this is open to all states. And you also do not have a nationality requirement in terms of a foreign investor. So the idea here is to open this up also for local companies or locally incorporated companies that are otherwise the requirements under 25(2)(b) of the convention. Next slide, please. So how does the mediation process work? And we put an overview here on the slide for you. We have the request for mediation that is slightly different in terms of the institution. You can commence it either with a pre-existing agreement to mediate, or a request for mediation may only contain an offer to mediate that we at ICSID would transmit to the other side. We'll look at this on the next slide. Then the request is registered by the Secretary General. After that, the appointment of 1 or 2 mediators by party agreement. Following that, we'll have brief initial written statement, much like what you may be familiar with from commercial mediations, as the case summaries provided to the mediator. And then the mediator holds a first joint session with the parties to discuss procedural aspects of the mediation and determine what we call a mediation protocol, which is then the guiding document on the basis of which the mediation will be conducted. And the protocol addresses something like procedural languages, a venue of meetings, next steps or procedural calendar, and any agreement between the parties regarding confidentiality, disclosure of information, what Alejandro already mentioned, not to institute or continue other pending proceedings such as arbitration while the mediation is ongoing. And then the conduct of the mediation, as I mentioned, is on the basis of this protocol, and termination options you have in the green box. So either the parties notify that there is a settlement that has been reached, or the parties agree not to continue the mediation, or one party decides to withdraw, or perhaps the mediator comes to the conclusion that there is really no likelihood of resolution. And if the parties do not take any steps towards the appointment of a mediator for an extended period of time, the mediation also terminates. Next slide. Thank you. So here you have the institution. I mentioned that this is slightly different than what we have in arbitration and conciliation. In arbitration and conciliation, you need to have the written consent in place before you can submit a request. And here in mediation, offering the parties the opportunity to have mediation available. We added an institution mechanism that the request for mediation can contain an offer by one party to mediate. The Secretariat then transmits that offer to the other side. The other party indicates whether it accepts or rejects the offer. And if it accepts the offer, then we continue with the screening process and the registration of the request. Next slide, please. I put on the slide here some general procedural provisions, sort of principles. Costs of the mediation can be agreed by the parties as to the principle as each party pays its share, but they may also agree that one side bears all the costs of the mediation. Confidentiality, we try to keep that simple here, that all information relating to the mediation and documents generated in or obtained during the mediation are kept confidential, unless, of course, the parties agree otherwise, or the information or document is independently available, or disclosure is required by law. Alejandro spoke already to that these affirmative disclosure requirements in domestic legislation are recognized here. And much like the Article 35 in the ICSID Convention, we have a without prejudice provision that positions taken or admissions or offers of settlements during the mediation may not be relied upon in any other proceeding relating to the dispute, unless the parties, of course, agree otherwise. Next slide, please. So here we have just an overview of when can mediation be used. When we first started to work on mediation, there seems to be an understanding that mediation is limited to the cooling off period. But it is not. Mediation is a concept of facilitated negotiation, is really available whenever the parties consider negotiation as a suitable tool. So that could be at the beginning, at the pre-establishment phase, for example, or the agreement to establish the investment, concession negotiations, for example, or also when a problem or an issue or a disagreement at that point first arises. I should add, what you see on the slide is the vocabulary of the conflict continuum that my colleague at the World Bank, Roberto Echandi, developed. That then from a difference, from a disagreement, it morphs into a difference, a grievance, and then at the time of the notice under a treaty or other instrument, it's called an official dispute. And then, so you see on the slide that the mediation is available throughout that time period of the conflict, including cooling off, or also alongside the arbitration. And that is possible and perhaps likely, we've seen it already in practice, that parties agree to suspend the arbitration and engage in mediation of all or certain parts of the disputes. And then the parties could agree to incorporate the mediated settlement into the award of the arbitration. And we've also heard that there have been several mediations after an award has been rendered. So mediation is at that stage possible as well. Next slide, please. So what are ICSID's mediation activities? The member state consultations on the mediation rules continue. We're aiming to have them adopted as soon as possible, and I am currently working on the working paper number 5 that we will send to member states in the upcoming weeks. We already offer the administration of investment mediations, and the parties can and already have agreed on the mediation rules as they currently stand. Capacity building activities, together with CEDR and the Energy Charter Secretariat, we conduct the investor state mediator training. We've done training for government officials, also with Energy Charter and CEDR, and also with colleagues at the IFC. General awareness raising on mediation like today, and technical assistance workshops for specific countries upon request on investment dispute settlement mechanisms we also offer. And I also have the pleasure to work together with Judith in cooperation with the UNCITRAL Secretariat to develop and look at guidelines for investment mediation and looking at clauses that states may wish to consider to include in their relevant instrument, treaties, contracts, or otherwise. One more slide, I think we do. And so what is the bigger picture? And that seems to be important to just look at mediation. It allows to maintain a long-term relationship between the investor and the state, if that is the goal. Diversification of investment here as the buzzword. Many companies would like to expand, but then retract or abandon their investment for a lack of effective dispute resolution, especially for those who do not wish to go down the arbitration route. And so that leads then to the economic development and the foreign direct investment retention that I mentioned. International legal framework, the treaty developments we covered, the ICSID mediation rules fill that, those treaty developments to offer specific investment mediation rules, and then of course the Singapore Convention. Dispute prevention efforts, here on the slide you have the reference to the World Bank's mechanism, which is called the SIRM, or sometimes it's called IGM, to assist the resolution of the investment dispute before it gets in the waters of a notice or an arbitration. And then I really want to highlight what Alejandro already presented on the domestic legal framework reform, addressing the organizational aspects within the state, a lead agency, encourage the use of mediation and anchor that in the domestic framework to fully allow the state to participate, and here the reference then to the model instrument. And with that, I thank you, and over to Fan.
Thank you so very much, Frauke. And it's very encouraging to see that the ICSID mediation rules have broadened its scope of application and made it more readily available than the previous, the ICSID conciliation rules, for example. And of course, as Frauke already commented on this, the availability of mediation as a process to resolve these investment disputes is one thing, but the willingness to participate and to engage in this mediation process is perhaps another. And the government states they have very different concerns and restrictions more often when it comes to resolving investment disputes with investors. And so in that regard, perhaps the Energy Charters model instrument may well or potentially could provide a good answer or some guidance for further considerations. And thank you very much. We will come back to you again, Frauke, at the Q&A and for some further follow-up questions. For example, the enforcement issue, I'm sure other speakers may well touch upon that as well. So let's move on to our next speaker. Our next speaker is Mr. Wolf von Kumber. Wolf is an arbitrator, mediator, and also the ISDS advisory group. And his topic for tonight is the investor-state dispute resolution from a mediator's perspective. And Wolf, over to you. Thank you.
Thank you very much, Fan, and it's a real pleasure to be here together with my colleagues. And I think we are touching on a topic here which is becoming extremely popular. I can just refer to an event we had at Harvard in 2019 where we brought together really the thought leaders in ISDS and mediation to see how mediation and ISDS could develop together. And a year later at BICL in London, again virtually this time, we brought together a similar group. And it was amazing to see actually the enthusiasm that the various stakeholders in ISDS really had for the use of mediation in the process. And I think, as Alejandro and Frauke have already explained, there's a growing framework within which mediation is developing and being utilized in ISDS. And I think that will simply grow as demand increases. I think as Dr. Quadong said at the very beginning when he introduced the topic, this is an extremely important topic for China as well, and Belt and Road in particular, as Belt and Road expands the need for an appropriate disputes mechanism has also been recognized. And mediation, as Frauke has already explained, is an important way for relationships actually to be maintained. My own background is that of a in-house counsel. I worked for many years for a number of global companies that invested worldwide. And one of the issues we always had when dealing with government and problems that arose in investments was how do you actually address those issues and the conflicts that arise in a meaningful way without jeopardizing the investment itself. And while arbitration has grown as a mechanism to deal with investor-state disputes in ISDS, there are also other ways that can be utilized in conjunction with arbitration to actually deal with those issues. And that's really what I'd like to explore with you a little bit today. So dealing with it more from the investor perspective, and perhaps from the mediator's perspective, which I can talk to. So maybe the first slide, if we could move on to that, and looking at why mediation really works in ISDS. And Frauke has already touched on some of those points, but maybe just stressing those again is important. Mediation, as you've already heard, and for those of you that have actually been involved in mediation, is a very different process from arbitration or state court litigation because there isn't a determination made. The mediator is a facilitator and helps facilitate negotiations between parties, but doesn't render a decision. And the mediator is a neutral. So the mediator is somebody that is not involved in the dispute and thereby brings to the dispute a neutrality and a position of looking at the issues in the dispute, which is very different than the parties themselves that clearly have an interest in the dispute. And so looking at it from an investor's perspective, where you have made an investment in a host state and issues arise with respect to that investment, mediation and bringing in a neutral to help facilitate the discussions between the state and the investor makes a lot of sense. And if you do it early enough, as Frauke showed in her timeline, not when the dispute has become protracted, but rather when the dispute or even the conflict first starts to arise, it allows for a discussion to take place in a forum which can lead to a resolution, which often is pragmatic, not simply rights-based, looking at the legal positions of the parties, but rather looking at the interests and needs of the parties. And this is what makes mediation so powerful, because you can often get solutions which you just will not get through an arbitral award or a court judgment. And often solutions that can, in fact, broaden perhaps the investment rather than terminating the investment itself. And particularly, as Frauke already pointed out, for foreign direct investment, it's actually a very valuable tool for states to utilize, because it's a tool which demonstrates to investors that the state has thought through how it will deal with issues that arise in the life of the investment, and that it's providing the investor with a particular mechanism which will allow for a facilitated negotiation to resolve the dispute to take place, rather than simply going to a third party to render a determination as to who is right or wrong. So we're dealing with needs and interests rather than rights. And so it's a very different mechanism to be employed. And that's why in the type of investment that Belt and Road, for example, is undertaking, having a mechanism which allows the investment to continue, but in a way where the dispute can be resolved through negotiation, is clearly a more effective mechanism than having a dispute go to arbitration. So what we're saying here really is states have a true interest in including mediation in their disputes mechanisms, And as Alejandro has pointed out, with the ECT model instrument, there is a framework that the states can put in place that can include mediation in their dispute resolution toolkit. The other thing I think that will really drive mediation in this particular area is the pandemic that we've all suffered through this last year, and which we continue to have to deal with into the foreseeable future for certain. And that is that because the pandemic clearly interferes with investments, because governments have had to take actions that might curtail an investor's rights within a state, it will probably lead to more ISDS disputes going forward. And clearly there has to be a mechanism to deal with those disputes in an efficient and cost-effective manner. And again, I think this will drive many states to looking at mediation as a possible way to deal with these disputes that could be coming down the road. What we've already said is that such disputes, investor-state disputes, require existing legal relationships to be renegotiated. So it's often that the investment climate has changed, maybe government has changed in a state. There are new needs, either social or political, that arise in a state. And a long-term investment, because many of these investments, of course, last decades, it's very difficult to foresee how that investment will evolve over time. And so there has to be a mechanism for the state and the investor to be able to look at that investment again and the contractual arrangement around it, and perhaps renegotiate it. And that's often where the issues first arise in investor-state disputes, is that there are changes in circumstances. And mediation provides a good framework for that negotiation to take place within. And it allows for, as I said, facilitated negotiation, which means that the parties have a much better chance of reaching a revised agreement. Of course, that's not what an arbitral tribunal would be able to award. It's going to be awarding damages, but it's not going to be able to renegotiate the contractual arrangement. But mediation does allow for that to take place. Perhaps the next slide, Anusha. So looking a little bit at mediation and arbitration, as we know, the current ISDS system really sees arbitration as a mechanism to be utilized. Although, as Frauke said, conciliation has always been available within the ICSID framework, but conciliation in a very different manner than the mediation rules that Frauke has described. And that's why ICSID has taken really a leading role here in helping to introduce mediation as another tool to be utilized. So we have a whole toolkit now. We've got arbitration, we've got conciliation, we've got mediation, and so the parties can choose from those different mechanisms and employ the one that they feel is best to try to resolve the dispute that's arisen. What I'm trying to say here is really that mediation and arbitration are really tools that can be utilized together. They don't have to be siloed and dealt with separately. There is really a growing movement towards combining these various methods together so that you can utilize them as needed to try to resolve the dispute over a period of time. So you can use mediation, and if that fails, you can then move to arbitration. But increasingly, people are starting to look at using them concurrently so that you have the mediation mechanism set up to run concurrently with arbitration. So you might actually commence the arbitration, but also then have a separate neutral appointed to deal with mediation. And so as certain aspects of the dispute are dealt with by the arbitral tribunal, and the arbitral tribunal sees that there might be opportunities for a resolution through negotiation, the matter might be stayed and then go to the mediator to see if the mediator can help the parties to come to a final settlement. Or there might be a particular issue that has to be determined by the arbitral tribunal before the parties can actually try to negotiate a settlement. Or perhaps the parties will simply then negotiate the actual damages once a determination has been made by the arbitral tribunal. So you can see there are many different combinations, but if you've got the awareness and the mechanism in place to also allow for mediation at the same time, it makes the whole process much more flexible, and you can come to a much better result at the end of the day. And there's also certainly in commercial mediation a drive to utilize actually the same neutral or neutrals to deal with both the mediation and arbitration phase. Now that's something that in certain parts of the world may still be frowned upon, because once a neutral as a mediator has received confidential information, it's difficult to put that aside when you become a decision maker in the arbitration, and then being able to render an award based solely on the information that you got in the arbitration. And so that is still an issue that is being wrestled with in this med-arb-med type of scenario, but it's happening in parts of the world. Certainly Singapore has a process where that is actually put in place so that the same neutral can deal both as mediator and arbitrator. And if the parties consent to it, then it's something that is certainly permissible in jurisdictions like Singapore. Maybe next slide, Anusha. So we've talked a lot about the framework, and Alejandro and Frauke have set that out. But there are issues that arise and that I myself have experienced when you're dealing with states that are unique to states and that don't arise to the same extent in commercial mediations where you have two businesses that are mediating a dispute. One of the key issues that have been discussed is that the state officials are, of course, in a unique position. They're representing the state. They're speaking for the state when they're negotiating with the investor. And that puts the state official themselves in a very awkward position. Do they have sufficient authority actually to settle the dispute? Do they themselves feel that they are vulnerable to being criticized if they determine and enter into a settlement with an investor? Those are real concerns, particularly in certain parts of the world where state officials could be treated themselves personally quite harshly and face not only loss of their job, but potentially also imprisonment. So they're going to be very concerned about that. and that has to be dealt with. And that's why the model instrument that Alejandro has presented is extremely effective, because it puts in place a framework for allowing negotiation and mediation to take place. It's part of the process within the state. And so the state official can actually point to that and say, this is the process, this is where I get my authority from, and this is where I have the ability to actually settle a dispute. And that takes away some of those fears that state officials have. A very important aspect here, and I know we'll probably discuss this a little bit more, is really transparency versus confidentiality. And you saw in the ICSID rules that confidentiality is an important aspect of the mediation process. And it is an important aspect of it because it allows parties to speak to the mediator openly and reveal things that they wouldn't necessarily reveal to the other party. And so this then, however, when you're dealing with the state, becomes an issue, because states don't want to be seen to do things in secret. They don't want to have secret deals with the investor and then later be criticized. They want to have the ability to actually explain what's going on. And so there has to be some transparency within the process. And as the ICSID rules state, parties can agree to what degree confidentiality will be applicable. So the parties, in designing the process for the mediation itself, will certainly address transparency and confidentiality and how that can be dealt with, whether that's dealt with through regular press releases. And so you put in place a press protocol where there's a mechanism for the parties to agree what can be released to the public and how it's released to the public. But it's clearly an aspect that has to be dealt with in the process design for the mediation. State budgets are another issue that states obviously have to grapple with. But it's actually, in a way, mediation provides a much better mechanism for states than arbitration, in the sense that, of course, nobody knows who's going to be successful at the end of the arbitration. You can feel you have a good case, but of course, you never know what the tribunal is going to determine. And so states that suddenly have a very large award that is made against them suddenly have a hole in their budget, because they have to honor the award and find the money to pay it somewhere in their budget. So they have less control of how they actually manage that than in a settlement. Because in a settlement, of course, that's part of what can be negotiated is the payment schedule as well. And so you have much more control as a state, obviously, if you can actually enter into a settlement agreement. So state budgets, clearly an issue, but probably dealt with better in a mediation forum. As we've already said, I mean, for a state official, arbitrating is an easy way out, because they can simply turn the decision over to somebody else. They don't have to make the decision. The arbitral tribunal makes it, and if it goes against the state, they can simply say, well, that was the arbitral tribunal. That had nothing to do with me personally, and we now have to pay because there's an award that's been rendered against us. So it's again this shifting mechanism that has to be dealt with through something like the ECT model instrument. And the other aspect, of course, and that's part of what we're doing here today, is really educating both investors and states as to how mediation can be utilized. The outside counsel that deals with ISDS, many of the state officials, they of course understand the arbitration process in ISDS because it's been there for a long time. but they don't understand necessarily the mediation process. And it's a matter of awareness building, capacity building, and that's precisely what we're trying to do here. Next slide. And Frauke has already touched on this. I won't go through it in any detail, but the modern bilateral investment treaties now increasingly are incorporating mediation, or the mediation process, into the treaty. So that actually creates, over time, as we have more of these, a legal framework for states to look at, and that again helps very much for state officials to be able to utilize mediation, because it's part of the process. It's in there. Often it's the investor that actually has to invoke the process. So the investor has the ability to do it, and the state, because it's in the treaty, then has to comply. And so it just makes it much easier for states then to utilize mediation in that format. And then just the last slide, I think, Anusha, if we could move to the last one. Right. So we've already looked at a lot of the progress that's being made in this area, and the initiatives that are being taken by bodies like ICSID and ECT and CEDR to ensure that there is a framework for mediation to take place in ISDS. And we're going to hear more about what UNCITRAL is doing there from Judith as well. And I think at the conclusion of Working Group 3, we're going to see that there's much more of an emphasis on how mediation can be utilized in ISDS. So I think it certainly has a bright future. Thank you very much.
Thank you, Wolf, and for highlighting the opportunities and some of the challenges, the obstacles to the use of mediation in resolving investor-state disputes. We will come back to you later on, perhaps, for example, how best to deal with some public law issues in the mediation process when corruption, for example, is alleged. And you mentioned the MEP, the timing of the mediation. We will come back to you at the Q&A later. And now we have to move on. And our next speaker is Mr. Ren Qing. Mr. Ren is an arbitrator of the Shenzhen Court of International Arbitration and partner of Global Law Office. And his topic for tonight is Investor-State Mediation, a Chinese Perspective. And Mr. Qing, over to you. Thank you.
Yeah, thank you very much, Fan. It's a great pleasure for me to participate in this webinar and to share some observations about investor-state mediation from a Chinese perspective. Just now, Wolf has already given a very comprehensive introduction about the advantages and perceived obstacles for mediation in the area of investor-state dispute resolution. I will follow up to share the observations from a Chinese perspective. Okay, thank you. My presentation will consist of 3 parts. The first part is from a Chinese perspective, why mediation is important to resolve investor-state dispute. The second part is the current status of the use of mediation in investor-state dispute resolution in China. And the third part is some suggestions or some observations about the ways we going forward to promote mediation in this area. The first part, why mediation is important, particularly for China. we can see this is a slide. This is a slide about the inbound FDI, foreign direct investment into China. As you can see, as of the end of 2019, the total value of FDI realized in China is US dollar, more than 2,000 billion US dollars, and there have been more than 1 million foreign invested enterprises established in China. So more than 1 million foreign invested enterprises in China. You can imagine, even if there is 1% of the enterprises have some problems with the Chinese government, there will be 10,000 disputes with Chinese government. So that is, so potentially there could be a very large number of investor-state disputes within China, potentially. The second, okay, the next slide is about outbound FDI. I mean, from China, the investment made by Chinese investors in other countries. As of the end of 2019, 27,000 Chinese investors have established 44,000 foreign invested enterprises in 185 countries. This data is from MOFCOM, Ministry of Commerce of China, which is in charge of outbound FDI as well as inbound FDI. On the right of this slide, you can see the countries which receive the largest shares of Chinese outbound FDI. These countries include United States, Netherlands. I'm sorry, this is not about the countries receiving Chinese FDI, but about the largest countries of capital exportation. China now is the number three. The third largest countries with FDI stock overseas, only after Netherlands and the United States. So potentially there also could be a very large number of disputes between Chinese investors and foreign countries, the government of foreign countries. Okay, so the previous two slides are about, I mean, just potential. Now the next slide is about the real investor-state disputes up to now. This slide is about the cases filed by foreign investors against Chinese government. As you can see, there have been eight investment arbitrations. Most of them have been filed at ICSID, and there are also ad hoc UNCITRAL arbitration. Next slide. The next slide is about the disputes. Disputes filed by Chinese investors against foreign countries. As of the end of 2020, there have been 7 cases filed by mainland Chinese investors. I mean, investors from mainland China. If we include investors from Hong Kong, from Macau, then there will be another 7 or 8 cases. including some Chinese state-owned enterprises, whose investment have been expropriated by foreign countries, and also include some private-owned Chinese enterprises. For example, last year, Huawei Technology has filed a notice of dispute against the government of Sweden. Okay, so the number of investor-state disputes increase quickly, particularly in recent years. The next slide is about another reason why mediation is important. The reason is the high costs of investment arbitration. On the top of this slide, it's the average cost of investment arbitration. You can see the median of the total cost of one arbitration case is about $7 million, a very large amount, particularly for SME. We also, here is a Chinese case, a case between a foreign investor, Anson, a Korean company, and the Chinese government. In this case, the cost of the councils, the costs of the PRC councils, the councils of the Chinese government, amount to 300,000 euros, plus more than 3 million RMB. That is about $400,000 US. So this amount, it seems that this amount is relatively smaller than the median amount I just stated before. But the reason is that this case concluded at the very beginning, because the China made a early dismissal request, and the arbitration tribunal upheld China's application for earlier dismissal. So if this case continue to jurisdiction stage or to the merits stage, then I think there will be again millions of US dollars for each side, for the council's legal fees, for the claimant side and for the Chinese side. So in view of the high costs, mediation with low cost and with this speediness has great advantages for resolving investor-state disputes. Okay, now we come to the current status of the use of mediation in the context of China. First, mediation is widely used in commercial disputes in China. There are standalone mediation. For example, the CCPIT Mediation Center is a standalone organization. And there are also mediation arbitration, mediation plus arbitration. For example, Shenzhen Court of International Arbitration, the model clause of their mediation center reads that the parties can first submit a dispute to the mediation center. If the mediation fails, the parties can proceed to submit for arbitration. And the third type is arbitration, mediation, and then arbitration. So during an arbitration proceeding, the parties, if they wish, they can ask the arbitral tribunal to mediate the dispute. If the mediation succeed, then the tribunal can issue a award to record the result of the mediation. If the mediation fails, the arbitration tribunal can proceed with the arbitral proceedings. So mediation is widely used in commercial disputes. Come to investor-state disputes. There are space for mediation in Chinese in international investment agreements signed by China and other countries. For example, there are consultation requirements in over 90% of Chinese IIAs. So the parties have to consult with each other. So during this phase, there is a space for mediation by a third party. And also there is a cooling off period. And in some of the Chinese IIAs, there are express mediation provisions. For example, in China-Netherlands BIT, it provides that parties can submit a dispute to ICSID for conciliation or arbitration. So the parties can choose. And a more unique international investment agreements signed by China is that signed by the mainland China as one party, and Hong Kong as the other party. That is the CEPA. In CEPA, there is no arbitration. There are various options to resolve disputes between Hong Kong investor and the mainland authorities. There are 6 options, and the fifth option is mediation. Currently, the mediation organization recognized under CEPA is CCPIT Mediation Center and the CTAC. Next slide. Next slide is mediation mechanism within China. In China, there is a special complaint handling mechanism for complaints filed by foreign investor or foreign invested enterprises. These kind of organizations had been established many years ago, but it is emphasized again in the new foreign investment law adopted in late 2019. In the new law, it is required that a national center should be established, and such centers shall be established at the provincial level, municipal level, and county level. That means within China, there are more than 2,000 complaint handling center to receive complaints by foreign investor or FIEs and try their best to help coordinate and resolve any disputes between the investor and the local authorities. So that is a very special mechanism of mediation. I believe we should read mediation in a broader manner. The mediation of a formal international investment dispute, of course, is an investment mediation, but such mediation within a state to mediate a dispute between FIE and the local authorities should also be viewed as mediation. Okay, and the next slide is about two cases. China is involved, or Chinese investor is involved. We can from this case to know more about whether mediation really works for investor-state dispute. The first one is the case between ADR, a Malaysia company, and China. This case was initiated in 2011, registered at ICSID and this case has not entered into arbitral tribunal was not established, but the case was discontinued. The reason for the case to be discontinued is that it is said that the parties have settled the case. To my knowledge, there is no third-party mediator involved in this process, but the investor and China and the Chinese government has managed to settle this case by themselves. Although mediation is not involved, but I believe that since settlement is possible, so mediation may be also possible for resolving investment disputes for which China is a party. This is for the first case, but the second case is a mixed picture. This case is also registered and ICSID as a conciliation case, not an arbitration case. The claimant is a company, is a joint venture between a Chinese company and an Australian company. So a Chinese investor is involved behind this case. This case, the claimant initiated the conciliation procedure, and a conciliation commission has been established, but the procedure have to be terminated because the respondent, the Papua New Guinea government, has not joined the procedure. So the procedure has to be terminated according to the ICSID procedure, ICSID conciliation rules. So from this point of view, it probably implies that conciliation or mediation cannot succeed if the host state does not wish to engage in such procedure. But if we look at this case closer, we will find that actually the claimant and the government reach a settlement agreement separately from this procedure. We from outside, we do not know whether the conciliation procedure put pressure to the government to enter into this settlement, but I believe that could be a factor to push the government to enter into settlement. Okay, so about some obstacles for mediation. Wolf has just give a very comprehensive introduction. I just add something from a Chinese perspective. For example, for the bureaucracy aspect, as you know, China is a very large country. Central government, provincial government, municipal government, district government. So if a dispute has arisen and a dispute has come into a stage as a very formal international legal dispute, it would be difficult for the central government to easily enter into to agree to invite a mediator to mediate the dispute. But I believe at an earlier stage, the government would more happy to accept a mediator to help resolve the dispute. And the sensitivity, my personal experience is that some of the disputes involve very sensitive issue. For example, the environmental protection. Now, Chinese government attach great importance to this issue. So for this kind of issue, it's not easy for the Chinese government to compromise. And some of the disputes have a systemic implication. That means in this province, there may be such a environmental protection measure, and in other provinces, there are similar environmental protection measures. So if one provincial government enter into a settlement with the investor, they need to think twice before they decided to do so, because they need to consider what implication will be for other for the similar measures in other provinces. And the last factor, the obstacles or concerns, is the many, in my personal experience, a number of or many investors have unrealistic expectations for compensation. For example, I know a foreign investor with only millions of dollars revenue each year claimed a compensation against the Chinese government for more than 10 billions of US dollars. That is unrealistic. So that in such a situation, it is unlikely for the government to agree to any settlement. So okay, finally, the last slide. The last slide is that the ways forward. Okay, the mandatory mediation, that means to provide in the IIAs to require the investor and the state to enter into mediation. I think that is not an option. And my personal view is that mediation at an earlier stage and within the host state. For example, in China, the complaint handling center is a useful tool to address or to mediate such disputes. And the third suggestion is that the investors is always the party to file a case, to file a dispute. So the investor has a responsibility to promote or to use mediation. And for this purpose, the investor should not to have an unrealistic expectation. Otherwise, it will not be likely for a mediation to succeed. And the last is we need professional mediator and mediation organizations. Okay, this concludes my presentation. Thank you very much.
Thank you very much, Mr. Ren. We are running out of time, so we will move on to our next speaker, Mr. Kamal Shah, partner and head of Stephenson Harwood's Africa Group. His topic for tonight is African states' approach to ADR. Over to you, Kamal. Thanks.
Thank you, Fan. Anusha, if you could move over to the slides, please. I'm going to cover in a few minutes the key stats when it comes to Chinese investment in Africa, touch on the private disputes that we know of between Chinese and African companies, and then move over to investor-state disputes, and then finally summarize other developments in Africa. So if we could turn to the next slide with the chart, Anusha, page 4, I think it is. If you carry on, please. Yeah, thank you. So that chart shows quite clearly the investment increase between 2003 to 2019. It jumped from something around $75 million to well over 2.7 billion. And the reality is probably much more than that. Next slide. This shows you how important China is to the investment in Africa. The main areas it is investing in are construction, energy, and transportation. That makes sense because of the hugely ambitious One Belt, One Road project, now called Belt and Road Initiative, which for a number of reasons passes through Africa. And it is a significant long-term plan for China, which gives it significant geopolitical advantages as well. And for Africa, of course, it gets huge investment and development, which is much needed. And very few countries around the world can do a project of that scale. Next slide. Now, with all these investments, you would think that there are lots and lots of disputes happening both on the private and the public sector, but actually the reality is very different. There are very few disputes we know of in the from the private sector, and of course the ISDS side as well. And I'll just touch on a couple to give you an example of the types of disputes we are seeing and what may possibly come in the future. Djibouti. The Djibouti port is a good example. In 2013, the government sold around 25% to one of China's largest ports operator called China Merchants. And a few years later, Djibouti terminated its concession agreement with a company called DP World in Dubai, who subsequently went on to commence arbitration both against Djibouti and against China Merchants. We don't know a huge amount about this dispute, but what we do know is that earlier this year, China Merchants committed to investing around $3 billion in an expansion of the same ports as well. This gives you a sense of the type of disputes which may happen when there's a large-scale infrastructure project afoot. Next slide, please. One of the other examples is an investment in Gambia in the fish meal industry. A number of Chinese companies were given rights to produce fish meal because of excess fish stock. There was a local, a group of locals who complained to the environmental agency because of alleged waste disposal practices, which led to the factories shutting down and promptly reopening following an out-of-court settlement. Again, we don't know a huge amount about this dispute, but there is a petition in the local courts ongoing. And very recently, there was a group of youths who allegedly burned down one of the fish meal factories, amongst other complaints they had generally against the government. It shows you again a combination of a formal dispute mechanism and negotiating tactics as well, which previous speakers have spoken about. Anusha, if you can skip 2 slides, please. I think a good summary of the private disputes we have seen, which chimes with what the previous speakers have spoken about, is the huge focus on negotiating, which China and African states have towards resolving disputes. Many disputes are resolved through negotiation, and therefore we never see them coming out in the public domain. And where negotiations may fail, there is a lot of engagement between Chinese and African states in terms of ministries and the government to try and resolve the disputes at that next level. And when that step fails, it tends to end up usually in arbitration, which we'll come on to, or local courts as well, brought by local investors. I expect that trend to change over time and much more of a focus around arbitrations as there is more and more investment coming in, and inevitably disputes will occur. Next slide, please. Moving on then to ISDS and ICSID. We have seen around 27% of cases relating to Africa since ICSID was set up. So around a quarter of all disputes relate to Africa. And in the past year, there were about 58 disputes, of which 15% related to Africa. But the interesting stat here is that not one of them, to my knowledge, was brought by a Chinese investor against an African state, which is quite surprising considering the amount of investment coming into the continent. Next slide, please. But what we are seeing is that although there are no ICSID cases, there are a number of ISDS type of cases coming up, and the slide there gives you an example of those, many of which settle. Even though arbitration is commenced, many of them settle midway, which again is a good sign if it's a win-win settlement for both sides. The latest case that we know of is a case brought against Ghana, government of Ghana, in relation to a China-Ghana bilateral investment treaty. It's around $60 million, concerned with the management of the traffic management system in Ghana. It's very early days, so we'll see how that develops in due course. Next slide, please. So again, by way of trends, there are very few ISDS disputes we know of between Chinese entities, Chinese investors, and African states. And even where there may be a treaty claim possible, it seems that they are not being brought either because of a preference to negotiate and settle, which is good, or because some of the bilateral investment treaties are not yet in force. And again, with time, I would expect, in my view, for these to be ratified and claims to increase over time. And in terms of other types of developments, perhaps we can move on to the next slide, Anusha. There is an important development a few years ago called the KJAC, which is the China-Africa Joint Arbitration Center, which has offices in both Africa, in Joburg, Johannesburg, Nairobi, and several cities in China. I do not know how well KJAC is doing. There are not that many cases which have been commenced, which is probably a good thing, but it is a good initiative between China and Africa to try and have these disputes resolved in a bespoke forum. The problem with that I see is that there are so many centers which I'll come on to that there is a confusion of choice really and what each centers offers. Next slide, please. And the next one, please. So moving on from the investment that China brings into Africa and how disputes arising are settled, apart from that, there have been a proliferation of arbitration centers in Africa. There's well over 80 or 90 at the last count. And that is obviously, in one sense, a good thing, but also creates a lot of confusion for both investors and joint venture partners as to which one is viable and really worth using to resolve their disputes. But the good thing is that there is a lot of choice, and many or most of them offer mediation as well as arbitration as part of the way they resolve disputes. So it's good from that point of view. There are two other very important initiatives which are meant for investors and states within Africa. So it's not really open to foreign investors as such. And those are the Pan-African Investment Code, quickly followed by the African Continental Free Trade Agreement, both of which are really important initiatives for Africa seeking to form a trading bloc and to take advantage of critical mass when it comes to investment and promotion of investment and ultimately resolving disputes. There's a huge focus, rightfully, on negotiating and settling disputes before they get to arbitration. But if that fails, there is a formal mechanism to use arbitration to be held in Africa using African centers as well. There is another development currently as we speak called the Investment Protocol under the ACFTA, which is the African Continental Free Trade Agreement. Over the next year or two, we will see the investment protocol being negotiated and finalized. And the aim of that is to try and bring all of these, what I call a spaghetti bowl of agreements and investment treaties and so on, signed by numerous African states into a much more manageable a way of resolving disputes, so to create less confusion and to increase the probability of disputes settling in an amicable way. So there is a lot of development afoot and more to come. And with that, I'm just conscious of time, so I will hand back over to you, Fan, to introduce the next speaker. Thank you.
Thank you very much indeed, Kamal. Very interesting data, sharing of data, and like our previous speaker, Mr. Ren. And our next speaker, Miss Judith Nieper, and she's the legal officer at UNCITRAL Secretariat, and the UNCITRAL mediation. Her topic tonight is the UNCITRAL mediation framework. And Judith, over to you. Thank you.
Thank you very much. So you are in control of my slides, and I would suggest that you go to the next slide. I have the difficult task to be the last speaker, so I'm probably between you and your dinner. And I have, the task is even more difficult because I have to come back on a much more general level. Now we had some regional focuses, and I would have to come back to somehow universal focus and present you to what UNCITRAL, the United Nations Commission on International Trade, did in that area. So if you could pass to the next slide. There you saw the building in Vienna where I'm sitting in for the first time since many months, by the way. So this is why I would like to stress that I'm really in the office, which is a good sign. So dispute resolution has been on UNCITRAL's agenda since its establishment in 1966, so more than 50 years ago. And from the very beginning, the Commission, UNCITRAL, had an eye on conciliation. And maybe by way of background, when UNCITRAL, in the UNCITRAL context, the terms conciliation and mediation are used completely interchangeably. So in the UNCITRAL context, for us, it means, and I'm referring to the definition in the model law, for instance, it's a process whereby parties request a third person to assist them in their attempt to reach an amicable settlement of their dispute, whether referred to by the expression conciliation, mediation, or an expression of similar import. So this is our definition. We do use these terms really completely interchangeably. We just decided, when we adopted the Singapore Convention, we decided to change the lead term. So nowadays, when we refer to that kind of procedure, we would use the term mediation because the Commission decided that this is better for promotional purposes and only for promotional purposes. So there is no substantial change involved in that change of terminology. So the first instrument was developed 40 years ago, the conciliation rules. So at that point in time, the term conciliation was more widely used than the term mediation. So you could see historic developments. And the mediation rules are some contractual rules for parties who wish to engage in such a procedure. And it seemed quite quickly, it appeared that the contractual solutions as provided for in the conciliation rules alone do not meet the need of the parties. There are certain issues that would require a legal basis, for instance, confidentiality, the role of the conciliator, the mediator in the subsequent proceedings, or the question of admissibility of evidence submitting during a mediation in a subsequent arbitration. And that's why in 2002, building on the conciliation rules, the Commission, the working group, developed the UNCITRAL model law on international commercial conciliation. And you see the cover of it on the slide. So this model law is a template for the national legislator who wants to engage in drafting a law on mediation and conciliation. And the idea of that law was to strike a balance between protecting the integrity of the process, while at the same time providing a maximum flexibility, preserving party autonomy and fair process. So the aim is to avoid overregulation and to avoid too rigid procedural recommendations, but to preserve mediation as a flexible instrument, but to also ensure the quality and the integrity of the process. At that point in time, in 2002, when the question came to the question of enforceability, the states didn't manage to come to one agreement. So you have in the 2002 model law, you have one Article 14, which states that the mediated settlement agreement would be binding, but enforcement is left to each state. And that has been done because states said at this point in time that the different enforcement mechanisms on the national level are so different that it would be impossible to really find a harmonized way to enforcement. Sometimes time is needed, so that's why 10 years in 2014, exactly, the Commission received a proposal by the US to work on a multilateral convention similarly to the New York Convention in the area of arbitration. And the argument was that mediation could not unfold its benefit because the result of such a procedure would not be quickly and efficiently enforceable. And the result is also visible on the slide. There has been a compromise to develop, on the one hand, the Singapore Convention because it has been open for signature in Singapore, and to update the model law from 2002. So you have in the model law, we added an additional section which deals with enforcement. And now states could choose whether to go for the ratification of the convention or for the adoption of the model law or for both. Currently, we have the convention opened for signature in August 2019, already entered into force on 12th of September last year, 2020, and we wanted to celebrate, which was not possible. So you find a video on our website where we try to have a virtual celebration. We become better and better in these kind of virtual celebrations. And currently we have 6 parties to the convention and additional 47 signatories. And we are getting signs that a number of ratifications are to be expected very soon. If you could go to the next slide, Anusha, please. So the projects that are currently on our table is first to update the conciliation rules. So not only change the name from conciliation to mediations to be aligned with terminology, but to also update these rules and to align them with the development of the last 40 years and with the new framework of the Singapore Convention and of the model law. So to make sure that we have at the end one harmonized arbitration, mediation framework, like we have a complete framework in the area of arbitration. The second text that is currently discussed is an update of the model law of the guide to use and enactment of the model law. So the model law, as has been updated in 2018, would be accompanied by explanations article by article, so that states that wish to enact the model law find further explanation, but of course also parties who want to use the guide. So the guide is based on the discussions that took place in the working group and will be hopefully adopted by the Commission. So it means that you would have authorized commentary, so to say, on the model law. And last but not least, we are developing some mediation notes, and the idea is to give a general introduction to what mediation means, and to explain to potential mediators, but also to potential parties, to those who would like to engage in a mediation, what to expect from the procedure. Next slide, please. So all of these instruments are currently at the have been reviewed by the working group and are currently have been revised, have been updated, and will then be in front of the Commission this year in June, July. And we, of course, do hope that it will be adopted. So all of these instruments and all of the instruments in the area of dispute resolution have always been drafted since the establishment of UNCITRAL in a generic way. And the idea is that these texts could be used in a wide variety of circumstances, covering disputes, a broad range of disputes, from between private commercial parties only, investor-state disputes, state-to-state disputes. However, at a certain point in time, it was noted that this generic application of UNCITRAL text to different types of arbitration posed a number of challenges, especially in the area of confidentiality. The states, being accountable to the general public, should be under a different transparency regime than purely private parties. And this is why UNCITRAL decided to work on that issue and drafted and negotiated the so-called transparency rules for mediation in investor-state treaty-based arbitration. And they developed as well a convention implementing these transparency rules to existing treaties, also known as the Mauritius Convention. And once these transparency standards, UNCITRAL transparency standards, were adopted, discussion continued, and it was discussed whether other specificities that arise purely in the ISDS context should be looked at by UNCITRAL and by one of the working groups. We had a number of proposals, and in 2017, UNCITRAL entrusted Working Group 3 with a broad mandate to work on a possible reform of investor-state dispute settlements. So the working group's work is to be delivered in 3 phases. First, to identify and consider concerns regarding ISDS, all concerns. Then second, to consider whether reform is desirable in light of these concerns that have been identified. And third, to develop solutions for those issues that warrant reform. And now we reached phase number 3. Why am I saying all of that? I'm deviating from my topic, which is mediation. And you will see on the next slide the reason why can you change the slide, please, Anusha? The reason why I'm saying all of that is because mediation is an important element in these discussions on the level of the reform options. So this is just a slide here to remind that we are trying to have universal discussions. So we do send out invitations to all of our 193 member states, and every session has around at least 100 states present and many other stakeholders. Next slide, please. So here you see that we have an increasing representation of states, also by least developed and developed states. These are still figures from before the pandemic crisis. But also in our now hybrid meetings, we do have a high level of participation. Next slide, please. And this is why I did all this very extensive introduction. Here you see that alternative dispute resolution mechanism is one of the key issues that is discussed by the working group. So the mediation was for the first time in October 2020 in front of the working group, and the working group said more or less had the same conclusions than the conclusions by Wolf earlier today. The working group noted the benefits of mediation, considered how such amicable dispute resolution methods could be promoted further and could be more widely used. And noting the need for creation of more stakeholder awareness, and requested guidelines, model clauses, and other tools that would help mediation to be promoted further. So the working group gave the Secretariat also some homework. This is how it usually works. We have a working group session. The working group is discussing, outlining what the Secretariat has to do in order to prepare for the next session. So in the area of mediation, our homework is to work with interested delegation and stakeholders to develop and adopt model clauses on mediation that could be used in treaties, to prepare guidelines, to make sure that mediation can be effectively used. And we are very lucky that Frauke is currently not only working on her working paper number 5, but is heavily engaged in helping us preparing the notes to respond to this request. And we do hope that we are able to publish the note very soon. You can jump 2 slides and come to the slides with the dates. So this is just the same idea of having all the topics that are in front of the working group now, and you see mediation plays an important role. So next slide, it's just a different way of visualization. So here you have the next meetings. They are not on mediation, but the May meeting will be on the work plan and on resources, additional resources, if we can get them to further advance work. This is important also for mediation, because we would know when mediation would be discussed next time by the working group, and when we would have informal discussions, formal discussions on the paper we are currently preparing with ICSID. As always, you find all the information on that work on our website. So as soon as we put the note together on mediation, for example, it will be published on the website. It will be translated into the 6 UN languages. You will find there the report from the working groups, where you have all the discussions outlined in detail, and you have the audio recording. So if you have a lot of time to stay at home, then you can listen to the whole session, including to the coffee breaks. Otherwise, you could read the report, which is a little bit shorter. So thank you very much, and looking forward to your questions.
Thank you, Judith.
By the way, if you go back 1 slide, you see that was working group 2 just after having finalized the ICSID convention. That's why everyone looks so tired but happy. If you just get back 1 slide, on the last slide you had the working group. Maybe. Yeah, so here.
Yeah, I can see.
Yeah, so everyone happy but tired.
Yes, they look exhausted.
Tired but happy.
Yeah, exhausted but happy. Thank you so much, Judith. And very impressive list of projects. And I have many questions, and I'm sure many participants also have many questions they would like to ask. But unfortunately, looking at the time, we have just about 3 minutes before we have James out to deliver the closing. So may I invite all the speakers to come back, online, yeah, and show your cameras. We're going to have a very quick Q&A session. With the indulgence of all of the speakers, may I propose that we will only perhaps deal with 1 area, maybe 1 or two questions. I think it's very important for us to conclude or end this, tonight's discussions here with some thoughts on the enforcement of the mediated settlement agreement. It's a topic that I think both Frauke and Judith will have a lot to contribute, to comment on. Would that be okay for all of the speakers if we perhaps just focus on this particular topic on the enforcement for the time being, given the time constraint? We have some questions on the Q&A box, and I see that our speakers have already answered by typing the answers there. Would that be okay? So if that's okay, then may I have perhaps Frauke on this topic of enforcement, just very quickly give us some overviews, your comments on how the mediated settlement agreement will be enforced under the current ICSID regime, please. Mm-hmm. Thank you.
Yeah, sure. Thank you, Fan. I'm happy to start with that. So if we look at the enforcement aspects under the current regime, if you do not have a mediated settlement, but if the parties negotiate that, then the options are certainly to include that in an award, assuming that these negotiations happen alongside an arbitration. And you have that in our statistics, that we have about, I believe about 10% of settlements are embodied every year in an award. The interesting thing in the investor-state disputes context is that you have about 25% of cases that end up without a settlement embodied in an award, but they still discontinue where the parties reach a settlement. And it is perhaps speculation, but based on that data, it seems to be that once you reach a settlement in the investment disputes context, it doesn't require necessarily enforcement action. The parties do not seek an instrument that you can enforce under the ICSID Convention or the New York Convention. Adding to that is, if you look at the ICSID cases that were discontinued, where there was a settlement, how many of these come back to ICSID because there is non-compliance? You would assume that in such a settlement they put a clause in that addresses potential disputes out of the settlement. So, and out of about 300 of these discontinued cases, only 3 came back. So that supports that idea about the different enforcement options. But certainly we have the Singapore Convention is another way of going about it, should that be required. And I'm happy to pass the ball to Vienna in only a second from DC over to Judith, who is certainly the expert on that.
Yes, please, Judith, over to you.
Yes, thank you very much. So it's difficult to really say how what the impact of the Singapore Convention will be, because we need first to observe the cases and we need to see how it goes. But what we could say already at this point in time, that if you compare to the New York Convention, it has been signed up to much more often than, so in the first year of the New York Convention, I think we had 28 states or so, and now we have already entry into force plus to the 6 ratifying states, we have 47 signatories, and they are all, to a large portion, they are now organizing the ratification process. Probably the biggest impact of the Singapore Convention is to be there, that you know that you conclude a settlement agreement and you know that it will be enforceable. So probably it's better to just comply with the settlement agreement. I think that is the main role of the Singapore Convention. And this is what a number of studies suggested that led to the work done by UNCITRAL, because it was somehow clear the lack of an instrument is a gap, is hampering mediation. But now that this gap is closed, and we are hopeful that, how did Wolf put it, a bright future? So we are hopeful that this bright future comes, and that we will observe in the future really the taking off of the impact. You're muted.
Thank you. Thank you so much, Judith. Absolutely. So now maybe we have James South, over to you for the closing remarks. Oh, let me just double check if any other speakers have anything to add or comment at this point. No, everyone is exhausted. James, over to you. Thank you. You're muted, James.
Thank you for that. And just to pick up Judith's point, that what I would like to do is focus on the bright future, because I've been an international mediator for 20 odd years, working in different areas. And I wanted to highlight 4 reasons why I think investor-state mediation is definitely going to happen based on experience in other areas of mediation. I mean, the first is you need substantive process, structural and institutional reform first in order to allow these things to happen, particularly when there's a strong status quo where there is here, for example, in arbitration. And you've heard from the speakers today that those reforms are taking place. We've got the ICSID rules. You've heard from Judith in relation to what UNCITRAL is doing, ECT's model instrument, and all the institutions themselves, SCIA, CEDR, etc., also making adjustments to provide that confidence to investors and the states that this is a process which can be used effectively with the support of institutions. The second reason is you need a body of experienced mediators, lawyers and parties in order to know how to act in a mediation. And we're seeing a lot of work now. For example, ECT, CEDR and ICSID have delivered 4 mediator training courses, so for specialized mediator training for investor state. 2 weeks or 3 weeks ago, we did training for state officials and how to represent the state in mediation. And of course, lawyers who are working in investor state disputes also have experience in commercial areas and experience of commercial mediation. So we're getting that body of experience of people working in investor state mediation. The third is awareness raising, and this is an event that shows that, and I don't know how many platforms like this I've been on in recent years, and that's quite a change from 5 years ago when there were no platforms like this. So that just shows you that awareness raising is a key part to answer the questions that many of the participants have asked in this during this Q&A. And finally, the final stage is clearly you need then successful mediation. We can talk about it, we can train people, we can get all the changes to procedures and things, but we need mediations to happen, and they are happening. We are seeing some initial signs of mediation cases happening. And that normally means that we have a virtuous circle. So people experience mediation, get success, they understand then how it really works. It's like a light bulb going on. And then they talk to their colleagues, and then mediation practice begins to develop as word spread, as the process gets more credibility. So for that reason, those 4 reasons, I believe we're in good shape for investor-state mediation to happen. And I will end on that point, on that sunny future point. It is late, I know, in China. And just finally, to thank all the partners that have worked on this seminar, and particularly to Stephenson Harwood, who were the convening organization. And thank you for those of you who are still with us at the end of the seminar.
Thank you so much, James. And with that very positive concluding remarks, I'm sure that we can all have a very good night's sleep and good day there. And may I also take the opportunity to thank my colleagues and Sophie and Anusha and Tini and Yota, all the colleagues work from behind the scene that have made this webinar possible. And thank you all, and hope to see you again soon. And good night and good day.